I love the tech. Order, order. Can I welcome you, Home Secretary and Mr Hobbs, to our session looking at the work of the Home Office. We have a number of questions for you, as you can imagine, but just so everyone understands, we recognise we do have a hard stop due to Prime Minister's questions, and therefore we really need to be focused on our questions and focused on answers. So we will be looking at two areas of the work of the Home Office, and the Home Office, we know, is a very, very broad animal that covers many, many things, but we're going to look specifically at issues surrounding immigration and asylum, and then we're going to look at policing in light of the White Paper and other issues regarding policing. So I hope that makes sense, and we're going to start with issues around routes to settlement. I'm going to start with Joni Reid. Joni.
Thank you. Good morning, Home Secretary. Thank you very much for taking the time to come this morning. As the Chair said, I just want to begin on the routes to settlement. As you see it, what's the fundamental problem that your reforms are trying to resolve, and what's the core objective of them?
So the reforms for settlement are precipitated by the issues in relation to the scale and pace of recent migration into the country. So between 2021 and 2024, net migration stood at 2.6 million people, which means that around 1 in every 30 people in this country today arrived in these 4 years. And we've seen particular issues in relation to some types of work visas, in particular with the health and care visa for social care workers, where there was an intention to fill a gap of between 6,000 and 40,000 workplaces, but in fact 616,000 people arrived. So on any measure, the numbers that we've seen in the last few years are unprecedented. There isn't any other equivalent period where we've seen such a large number of people arrive, and such a mismatch between what the expectation was and what has in fact happened. So I think on scale and pace and also the unprecedented nature of what we are seeing, I think it's something akin to signing up to free movement with the European Union. That's the sort of, historic sort of only other comparator that you could possibly look at. I think the other particular feature here is the changes to the rules made in 2020 on what would be allowed under the skilled worker route. Those changes where it was dropped to below RQF level 6 has meant that we've just seen a much bigger range of lower skilled migration as well. So in 2021, only 13% of skilled workers were below RQF level 6. By 2024, that had risen to 53%. So on, as I say, on any measure, these are huge shifts in the type of legal migration that we've seen into the country, and I do think that they demand a new response, particularly as the people that have arrived are soon due to be, without any change to the rules, will be applying for settlement in the next few years. And we do expect those numbers to peak. And as I say, I think it's something like 1.6 million on our central estimate would be the number of people that are applying for settlement. So the scale and pace, the unprecedented nature of it, the particular element around the lowered requirements for skilled workers, I think do demand some fresh answers from the government.
Thank you. So what I'm hearing is really about deterrence more than anything else, and that you hope that it will reduce the net migration numbers. What evidence can you point to that that's the impact that those reforms will have?
So I wouldn't say it's deterrence. There is a particular issue where we've seen a very, very large scale of migration into the country, much more than was expected, of a very different nature to what we've had before, both in terms of the skills range, the number of dependents. I think something like 50% of the care work numbers are accounted for by dependents of workers. Again, unprecedented numbers that we've not seen before. So I think that demands an answer from us, because at the point of settlement, without any change, all of those individuals are of course able to access social housing, access to the welfare state, and because of the lower skilled nature of many of these people in terms of their salary expectations, you can expect that there will be a correlation between those numbers and then those who may then require assistance from the state having achieved settled status if we don't have a change in these rules. So it's not, I wouldn't mischaracterise it as deterrence. It is about managing what has been an uncontrolled wave of migration into the country, and I do think that we have to consider what the impacts would be if, with no changes, all of these people were able to obtain settlement at 5 years, which is what the current rules would allow.
We've heard quite a lot of evidence from various third sector and local organisations who've put the argument to us that this is going to have a negative impact, particularly on integration and cohesion. Is that something that you accept, that extending that length of time will inevitably have an impact on integration?
No, I disagree. Actually, if you look at our paper on the new proposals around earned settlement, the intention is to restore the element of contribution at the heart of the system. I think that our country is full of very tolerant people, very generous people. We're very open, but I do think there is a condition to that, which is about contribution. I think that if people feel the system is fair, well controlled, and that the people that arrive are contributing, and that is demonstrated and rewarded in the system, I think that does unlock actually a greater sense of cohesion. So I would disagree. Also, we are talking about people who are coming here to work. It is not unusual for any country in the world to want to change the rules, change the mix of people that are coming into work, look at how we decide how to fill our labour market shortages, and also to place expectations upon employers that they have to fulfil before they're able to bring workers here is absolutely, I think, perfectly legitimate, that we want to be able to make sure that first and foremost employers try to recruit people from home, that we have a better training and skills offer for workers here before we seek to fill shortages with workers from overseas. So I think it's perfectly fair and legitimate for us to want to have a controlled system that does place, burdens on employers. You can't just go off and bring people in from abroad. You have to play by some rules as well. I think that's fair enough, and I think that's what the changes are designed to do. Which, of course, we're consulting on some of the detail of the proposals, but the thrust of it is to obviously focus on getting a managed system that is well controlled, that deals with a particular problem that we saw over the last few years with such a large scale of workers, lower skilled workers coming into the country, and I think that the totality of it can help us rebuild the case for a strong migration system that retains public support.
And the final question from me, how do you distinguish between earning settlement and simply just delaying it? What's the kind of fundamental difference, and how do you see that contribution working?
Well, I think we've already announced that we want to go from a baseline 5-year qualifying period to 10 years, which we're not consulting on. I think at 5 years, we have a relatively generous welfare state. I think at 5 years, that's actually quite a short period before people can be permanently settled in the country with all of the benefits that brings. I think it's right, therefore, that we extend it. And then in the range of proposals we've set out, there are obviously some things that could help you bring that qualifying period down. So if you're a particularly high earner, you've come through on any of the global talent routes, you're a higher band tax payer, you can earn that period down from 10 years to potentially 3. But then the reverse is true as well. So if you do fall upon the state and you end up accessing benefits, that can increase your qualifying period. I think it's showing that contribution, that staying in work, that making a contribution to the taxpayer, your good character, all of these things count towards earning settled status and a lifelong ability to be in this country. I think it's fair that we set some thresholds, that we refresh the thresholds we currently have, and are able to show the public that we're rewarding the behaviours that everybody wants to see, but that actually if you do fall upon the state, if you do end up accessing the welfare state, that you are then, it does take you longer, therefore, I think, to earn settlement. At the end of the day, this is a system of bringing workers into the country, so it is about managing economic migration. I think it's fair to have an expectation that those people are therefore making an economic contribution to the country.
But that's really just rewarding high earners, isn't it, as opposed to encouraging a contribution?
Well, I think, but I mean, you're only bringing in workers to benefit your economy, right? So, of course, you would want to look at earnings in that context. I don't think there's anything wrong with that. Successive governments have made the argument for wanting this country to be a country that can attract the brightest and the best. I think that's it will be odd if we weren't trying to do that. Of course, sometimes we have labour market shortages in areas where the skills levels or earnings capacities are lower. And of course, we have the Migration Advisory Committee that advises on that. But it does have to be in a controlled way. And what we saw under the previous government was a very uncontrolled growth in the number of lower skilled and therefore lower earning migrants coming to the country.
Thank you, Home Secretary.
I think it'd be fair to say that the real increase was sort of 2022, 2023. Have you seen any evidence that ministers had any control of what was happening at that time? Were they conscious and aware of the numbers that were coming in that sort of 2022-23 period?
Well, I am not, as you will know, able to see the papers of the previous government, so difficult for me, being in the building now, to be able to see exactly what was happening under the previous administration. Although what I would say is just the publicly available numbers did show a big increase, and certainly as a constituency member of Parliament, I mean, I know that in Birmingham Ladywood I was starting to pick up casework that related to people who thought they were coming to work in the care sector, and actually the provider ended up being dodgy, shut down, took all their money, and then they were left with nowhere to go. So I think it was becoming apparent fairly quickly that the big growth was challenging.
Ministers should have seen that. I mean, I was a minister in the Home Office at one point. I know the kind of controls that we had at that time and seeing of who was coming in and what was happening. So ministers ought to have been aware.
I think it's inconceivable that they wouldn't have been aware at all. Obviously, it'll be for them to explain what exactly they knew and when. But even if you just go by the information that was publicly available and you could see the big growths in net migration, I think it became very clear very quickly that there was a different nature to this type of migration in that year in particular.
That makes sense. Peter Prinsley.
Thank you very much. So thank you for coming this morning. So why are high earners more useful citizens than people who are not high earners?
Well, we are talking about a system of economic migration, so I think it would be odd to say that you're not looking at earnings. I mean, you're looking for people to come and work, and the intention is that they can support themselves. You're not looking to bring in people who will ultimately require assistance from the welfare state, potentially for the rest of their lives. The point is to be making an economic contribution, and of course, we are in a competition with countries around the world for the brightest and the best talent. We want to grow our economy. There are, big sectors, the tech world, in the development of AI, in our health service, where obviously there's global talent to be hunted after, and we would want to bring them into this country ahead of others. So I think, forgive me, but I would find it odd if we weren't trying to bring in the brightest and the best into this country. And of course, that does have a correlation with earnings as well.
Now, I quite understand that, but the demand in this country for workers is not always for high earners. We have large numbers of people who, for instance, work in the care sector, who are not high earners, but who are nevertheless extremely useful members of society, and we need to be able to attract people to come to work in those sectors. That's my first.
Yes, no, which I do understand, but what I would repeat back to you is that under the previous government there was an expectation of a market shortage for workers in social care of between 6,000 and 40,000. I mean, that is actually quite a big range, so it tells you that there's an unreliability in the understanding of exactly what the needs of that part of the workforce are. But I mean, there's no world in which you could say even at 40,000 that then you shouldn't have a response when in fact 616,000 people come. That was never what was envisaged. Half of them are dependents. I think it is right to then ask a question about what that means for the capacity of the welfare state to potentially absorb that number of people.
No, I absolutely get that. So some changes have already been put in place, and what I understand is that net migration may be falling to very, very low levels already. Do you anticipate, say by the end of this year, we may be in a situation where we've got more people leaving the country than are in fact arriving?
Look, I mean, I would dispute that net migration is at very, very low levels. It's still really quite high in terms of it. I mean, it's had a big drop from the very large increases that you saw under the previous administration, but it is still comfortably at around over 200,000, isn't it? Yeah. So, which on any measure is still quite a high range. I mean, when I first came into Parliament, we were talking about migration in the tens of thousands back in the days of 2010 onwards. So, I'd say it's still pretty high. I mean, I'm not targeting a particular fall in net migration through these changes. What I'm targeting is a better managed, controlled system that can deal with this very particular problem we've now got of many hundreds of thousands of people arriving in the country, half of whom are dependents. A change which was never planned for, never thought about, and which now leaves us with a big problem to fix.
Lewis Atkinson.
Thank you, Home Secretary. Can I just drill down on this? Is the issue the numbers that arrived, or is it the potential scale of the recourse to public funds as a result of the numbers? Because
I mean, the two are related.
yes, absolutely. But is a policy intention to, by a set of changes, encourage people who may have arrived to now leave? Or is it to actually to have the same amount of people, that 800,000 a year that you mentioned, staying here but have much more limited recourse to public funds, given social housing waiting lists and other issues that there are across the country?
Well, you know, we're consulting on the precise nature of whether you look at changing the rules on settlement and recourse to public funds. That would, of course, require primary legislation, or whether you simply extend the qualifying period to beyond 10 years for particular cohorts of lower skilled workers. So I think that is an open question, and we are genuinely consulting on that. The policy intention is to deal with a particular issue that we have seen. As I say, I'm not driving trying to get a particular decrease. Some of those individuals will find work and will be able to make a contribution, and we are setting the rules and consulting on those rules about how we measure that contribution, what that buys you on your qualifying period. But if you get to your qualifying period, whatever it might end up being, 10 years, maybe a bit longer, and you've made your economic contribution, you can fulfil the mandatory requirements, you will obviously be able to attain settlement in the country. So we're not trying to prevent anyone from ever getting settlement, but we are wanting to change the rules by which they do that. And of course there will be some workers that are not able to do that, and then they would not have a basis for remaining in the country either. But the thrust of the reforms isn't to say we want a particular cohort to go home or particular numbers. It's to get some order and some management into a system that I think we can all agree got out of control. So
there are a set of communities that would say, you know, we never came seeking public funds, and actually decoupling recourse to public funds to settled status, for example, linking it to citizenship rather than settled status, would be an option that would increase integration and manage the recourse to the public purse. Is that something that is still being considered?
Well, the consultation asks a very open question about whether the way to manage this particular part of the problem is to change what is available to you once you get settled status versus obviously just extending the qualifying period. There are pros and cons to both. On that particular question, the consultation is, you know, very. I am personally very open-minded. If you're seeking to change what happens at settled status, then obviously there's a knock-on of how you manage that. There are already people that have settled status in our country. We're not changing anything in relation to those who already have indefinite stay here. So there'll be some practical questions about which is the better way forward, but settlement does bring lifelong rights, and as I say in the consultation and in the paper that we published, settlement is a privilege, not a right. You know, in the end, this is a privilege for people who come to our country rather than our own long-term residents and our own citizens. So there is a distinction between those two, and I think it is right to see it through the lens of privilege rather than a right.
I'm going to move on to some specifics about the consultation in a moment, but Chris Murray with a very quick one.
Very quick question, Home Secretary, thank you. I just want to I can understand your argument about the public cost and about the uncontrolled numbers, but I just want to ask more sort of kind of question about your attitude towards the immigration system overall. So obviously settlement is a really important step, but it's a prerequisite to citizenship. So I wonder, do you want, when someone becomes a citizen of this country, they get a letter from you welcoming them to British citizenship. Do you want to be issuing fewer of those letters? are you agnostic about the number of people who make the journey to citizenship? And if you think about those dependents, those kids who came here with their parents as they took jobs in the social care sector, would you encourage those kids to aspire to British citizenship, or would you just be agnostic on that front?
We have got questions on to children coming up.
Yeah.
So just genuine citizenship.
So, I mean, at the moment, once you're here, there are still mandatory requirements to fulfil before you get settlement, but it's much more of an automatic process, I guess. And then beyond that, I think it's a year to citizenship after you've got settled status. So these are quite quick processes, actually. But I'm not seeking to limit the number on citizenship as opposed to settled status. Obviously, if you've made your home here, there's no meaningful difference between you as a citizen or as a long-term settled resident of the country, and there are good reasons why people don't want to lose their nationality of origin, as it were. But the full benefits of the state do accrue with settlement as the rules currently stand. So I think it is worth interrogating the relationship between the two, and again, quite open-minded on as we consult and look to make changes in the earned settlements status space, whether that has knock-on consequences for citizenship as well. For children, again, if people are wanting to make this country their home, then obviously we want to provide a pathway to do that, but that's why we want to think about the rules and the contribution that people make as part of that system. My family lived abroad when I was a child. My dad was a civil engineer, so he worked in the Middle East for a period, and for 6 years I was abroad as well. But it would never have occurred to us as a family that we were trying to accrue citizenship elsewhere. So in the end, these are quite personal decisions that families make, and then the state obviously has to set the rules by which everybody has to play. But I don't think we can get into the hearts and minds of other individuals, and in the end it's parents who bring their children over, it's parents who are ultimately responsible for the life choices that then their children have to navigate. I wouldn't say that that's the responsibility of the British state.
Okay, we're going to move on to the transitional protections, and Belle Ribeiro-Addy.
Thank you, Chair. I'm Secretary. I think you've covered what you think the purpose of the mandatory minimum economic requirement is, but we've heard that this proposal will affect a huge number of people, and regardless of the arguments about high earners and the best and the brightest, these are probably the exact industries where we currently have quite large shortages, and those that we called essential during the pandemic. So is the government considering transitional protections for people who are already in the UK that will be affected by this change?
Well, we ask a specific question in the consultation on transitional arrangements. So obviously with any of these changes that there are going to be knock-on impacts. What I would say on the mandatory economic contribution, we're looking at just the threshold for paying national insurance contributions is really quite low, actually. And one of the criticisms in Parliament when I made a statement on these changes was, in fact, that it might be too low. So, but I think that setting it at the threshold at which you first start making contributions, and you are in fact making national insurance contributions at that point, seems fair to me. Obviously, there will be some groups that can't meet that, and primarily, I would imagine, in the dependents, group. And so we will want to consider what, if any, exemptions or additional arrangements we want to make for those people. But we've had something like 130,000, I think, responses to the consultation. I'm sure there is a lot in there about carers, about people with disabilities, women who've had to take maternity leave, others who will not be able to fulfil the mandatory earnings requirement. So we are consulting, and we will look at all of those particular examples and think carefully about what additional arrangements we might make for those people.
Okay, and thinking of another group of people that it might affect, would it be fair to apply this requirement to households where one parent is caring for children rather than working?
Well, so I mean, again, I think having published the consultation, there's been, I think, some helpful discussion around whether you look at purely individuals' earnings or household income potentially. So, it's not unusual in our arrangements to consider the income of a whole household as opposed to just one or two individuals within it. Again, the consultation is open on this point, so I'm pretty sure we've already had some strong representations on this point as well. And it could be that you set a minimum income requirement, for example, for one partner. in order to, account for a whole household income system. But as I say, it is a consultation. We are genuinely consulting on these questions. We've done it this way because we know that there will be knock-on impacts, and we want to have considered them properly and carefully.
So there are going to be plans to assess people as households as opposed to individuals?
No, you shouldn't take what I've said as a plan. I've said that the consultation is genuinely open on this point, and we've already had representations making some of these points to us. We will look at the totality of the responses that we've received before we design the final policy.
Okay, so at the moment the Home Office does assess people as individuals, but I suppose why do that at the moment when people generally plan as households?
Well, so the initial proposals are obviously based on individual contribution being the means by which you earn settlement into the country. So that is the initial proposal that's being consulted on. But we are very aware that there will be knock-on consequences for those who cannot meet the test that we are proposing as an individual. And again, as I say, we've received many representations about both the sorts of people that could be affected and also the other means by which we might account for those individuals that fulfills the policy intention and stays within the parameters that we have set of the new system, which is that we want to reward contribution. So as I say, within those parameters, we're looking obviously at the consultation responses that we get.
Thank you. And in the evidence we've received from immigrants, we're finding that they've planned their lives around a 5-year route, that's selling property in their home country, turning down other jobs, delaying having children. Do you think it's fair to these people for the terms of their route to settlement to be changed after they've already arrived?
Look, I think what's fair is that a government and a country should be able to respond to the circumstances that we face. And I think that it's actually, we have 2 set-piece rule changes every year, usually in April and then in the autumn for immigration rule changes. It's not uncommon for us to change our rules. These are obviously bigger changes, but they are there because they're dealing with a much bigger set of circumstances. As I say, the numbers of migrants into the country between 21 and 2024 is an unprecedented level. The changes on the skills levels required to come to the country and the numbers of dependents that have arrived, I think does demand an answer from the government. And what you're trading off is a set of potential obligations to people who've come to the country versus your obligations to your citizens and your own long-term residents in the country as well. So there is a choice here and there's a trade-off here, and we're trying to find a balanced way through what is a very difficult problem. And I think that the proposals that we put forward are trying to meet that policy intention. But as I say, we do recognise that these would be big changes. They could have some unintended consequences. There might be groups that we weren't aware of.
I think we can take from this, it's a consultation and you are consulting.
It's a genuine piece of work, and I do recognise that there are big changes that are potentially happening here. What I would say, despite the fact that we're consulting, it is inconceivable that literally nobody who's currently here would be affected by any of these changes, and I think we should just be upfront about that. But beyond that, obviously, we will see what the responses say.
So do we think that people who would qualify for ILR today but couldn't afford to pay the application fee today would be affected by these changes? Would the changes apply to them?
Well, so the basis on which an application for indefinite leave to remain is assessed is based on the rules at the time that you apply. So that's always been the case. I think that was upheld in case law. It's been tested in court. It's been upheld in case law since 2009.
I think a lot of these questions are coming up because of the anxiety of retrospectivity. It's causing a lot of issues. So, yeah, that's the question. So if somebody applied today, if somebody had the right to apply today but couldn't afford it today.
So an application is assessed based on the rules that are enforced at the point at which the application is made, not what the rules were when the person came to the country,
not whether they qualify. It's when they apply.
It's when you apply.
So if they can't afford to do it today, but they can afford to do it afterwards, then
and it's
there
always
will
on
be the
point
rules
about,
at that point.
And that's the point I'm making, that it has been assess on the rules that are enforced at the point of application for many years. That is not a new change. It's not a thing that we've just done that's different. It has been tested in court in the past. There is 2009 case law on this point. It is the rules that are enforced at the point the application is made.
Okay, but just going back to the retrospective nature of it, what advice did you seek when deciding as to whether or not to apply the changes retrospectively?
Well, as I've said already, we've had a very large number of people arrive in the country, much more than were expected, in an unprecedented way. I think it does demand an answer from the government, because potentially, without any changes, a very large number of people, 1.6 million on our central estimate, become eligible for citizenship in the next few years. On any measure, that is a big new number for a country to absorb.
Oh, yeah, no, especially, it was more on the advice that you saw.
So what I've asked for are policy proposals to try to meet the challenge that we've got. And I think that what we have set out in our consultation is a new way of thinking about how settlement is earned in this country, how we might reward the behaviours we want to see, how we might take some time away from people, add on more time if, for example, they end up accessing benefits. It's a system of economic migration, and I think that the proposals we have are trying to meet that challenge.
Secretary, I think we need to move on. So we're going to move on to the impact on children and young people, and we did start addressing that, but Peter Prinsley.
Thank you very much. So yesterday we heard from a number of expert witnesses who spoke to us about the issues relating to children and young people, and some of it was pretty upsetting, frankly. I mean, the single phrase that I went home with was the idea that there was state-sponsored unwantedness. And we were feeling that there were hundreds of thousands of children who were kind of in limbo, who had come here, had either been born here or had come here when they were very young, and their situation was very, very uncertain. So the first question is, what are the justifications for putting children on different routes to settlement based on considerations completely outside of their control?
Well, I mean, we've taken out of scope of the consultation, by the way, those that are in care or who've arrived unaccompanied in the country. There were a set of commitments made in the immigration white paper by my predecessor, Yvette Cooper, on children that have been here for most of their lives and only at 18 discover that they don't have status, so trying to find a pathway for them. All of those things are unchanged by these new proposals. What I would say, though, if we're just looking at the specific proposals in front of us, I mean, the first choice to bring children over is, of course, on the parents, right? So, with respect, what I would push back with is if parents who come here to work choose to bring their dependents over, then that is a choice made by those individuals. Of course, we are the sort of country that wants to try to do right by people, but I think I think it's fair, when these numbers are unprecedented and much bigger than we've had for a very long time, to reconsider what are the benefits that accrue when you come to the country. We will, and again, there is the consultation asks questions on this. We will have to consider the treatment of children because obviously we want to move to a system where mostly you earn settlement as an individual in your own right, and there will be some children that arrive who are older, 16, 17, and at 10 years in a sort of standard qualifying period for their parent. It would be odd if you didn't have an individual treatment for somebody who's themselves 26 or 27 at point of application. So I think we're going to look very carefully at some of those issues and develop proposals to meet that challenge.
If a child came to the UK aged 10 and their parents don't achieve settlement for 15 years, when do you think the child would receive settled status?
Well, that is exactly what we're consulting on. We know that we will need to develop careful pathways to deal with this, the particular issue of children, and we will want to look at those who are older versus those that are younger in this new system. But obviously the policy is still being designed, and we are very open to what the consultation responses will say.
One of the things we heard about yesterday is sometimes there are families where there are several children. And what we understand is that there's a necessity to reapply every 2.5 years. And the fees at every 2.5 years are substantial. And we heard of situations where the family couldn't afford to make the application for all of the children. And they were in the situation where they were having to work out which of the children should have, for which of the children there should be an application, which seemed to me rather unfair on the children. I mean, it's a little bit like the two-child benefit we were talking about yesterday. if it's right for one of the children in the family, it should be right for all of the children in the family.
Well, but again, what I would gently point out is these are children that have been brought in by their own parents in a system of economic migration. People are coming to the country to work. I think it is fair for us to expect that people coming into the country to work are able to support themselves and their families. I don't. That is different to the asylum system. Those are two very different things. And of course, we know that there's a relationship between some parts of our work visa system and the asylum system because of the sheer numbers of people that switch out as soon as their work visa finishes into the asylum system. So there are particular problems there. But I think there is a distinction between a system that is designed to support the economy, where I think you can and should expect both contribution but the ability to support yourself and your family. If you brought your family over, I think it is fair for the state to consider. And I think most of our constituents and our citizens would think it's fair enough to say you should be able to support your family. And I think having a system of fees is also absolutely fair.
Okay. But I agree with that, but do you recognise that the scale of the fees is a problem for some of the families?
Well, again, we have to set fees at a level that is appropriate, and it's a privilege, not a right. I think, again, it would be odd if we had a system of no fees for some people, because we have to manage the system properly. There are fees attached to processing these. There are costs attached to processing these applications. So again, I think people make choices themselves to come to another country to work. There are always rules that you have to play by, and there are fees that have to be paid. I think that is a well understood part of the system.
So there is presently, I believe, a 5-year private life route for children and young people who've spent most of their life in the UK. Are you proposing to retain that?
So we will protect the position of those that are already here and in line with the commitments that were made when we published the immigration white paper last summer. But separately to that, there will obviously need to be a consideration of what's happening under the new system, and we will want to make sure that they are all coherent and sit together properly. Again, that is the point of the consultation. But the pre-existing commitments in relation to children we will fulfil and honour.
I think people will find that very reassuring. So just the last bit of this section is about the equality impact assessment. So what did the equality impact assessment identify as specific impacts of the changes that are being proposed on children?
Well, the Equalities Impact Assessment, it's a living document, so the policy is not yet finalised, it will change based on the policy choices that are made. It wouldn't be unusual that there will be bigger impacts on some groups than others. The question and the legal obligation is whether they are proportionate in order to meet the policy aim. So I will obviously look very carefully at what the assessment shows once all of the final policy decisions are made. It is also why we are consulting. We will obviously always fulfil and I will always fulfil my legal obligations here. But the key question ultimately will be, to the extent that there are impacts, and we can probably guess that there will be some impacts somewhere, is that whether they are proportionate to meet the policy aim.
And are you worried that there'll be an impact on child poverty?
Well, again, this is a system of economic migration. It is right for the state to expect people who are coming here to work that they will be able to support themselves. If they choose to bring their families with them, that they will be able to support their families as well. So the system is designed to make sure that people are working and doing what was intended, rather than needing to access the welfare state. So again, as we complete policy design, we'll have a better sense of what the impacts are likely to be. But if you just step back for a moment, you do have to start with what are the principles of the system, and why is the system of earning settlement, having come here as a worker, different to what happens to you when you're in the asylum system, because you're dealing with two completely different cohorts of people. There's lots of alignments between these two separate parts of the migration system, but I think it is right that a system of economic migration can show an economic contribution has been made to the country.
We're going to move on to medium-skilled workers and adult social care with Margaret Malone.
Thank you, Chair. Thank you, Home Secretary. I'm kind of hearing a theme through your responses today about fairness to the country, and essentially it's an economic argument, that kind of thing as well. So
the government has said that settlement should be earned on the basis of what you contribute to public life. So I think that sense of fairness would sit well with our constituents. But how is the contribution of adult social care workers been reflected fairly in the earned settlement proposals?
Well, I think that the proposals are fair and that they are trying, I think, to meet the scale of the challenge, which I won't repeat. I know we've got to get onto the topics, but I would just repeat the unprecedented nature of the numbers that we have seen, the huge scale of abuse that occurred in the social care sector. We've had to revoke something like 1,000 sponsor licenses in the care sector. So I think, A, it was right to close that route, which was open to such abuse as we saw. B, so many more people came than were expected to have arrived, and so C, that means there has to be a response. I think it's not just about the fairness to the workers that arrived, but also to the communities in which they live, given attendant pressures on social housing,